1.7, yes, but the relevant part of Sheikh Abdullah's speech is at page 101. PDF 101.
101.
Yes. In the submissions, I just put those paragraphs so that it doesn't waste time. But anyway, I'll refer to that. It's not in addition to anything.
That's 1460.
1460. That's absolutely right.
What is the date of the speech of Sheikh Abdullah?
I'll just give that to you.
This is in the Constituent Assembly, the J&K Constituent Assembly.
Yes, 5th November 1951. I'm not editing anything new, Malaj. I just, because I didn't want your Lordship's time to be wasted, so I only pointed those paragraphs. There's nothing new in these submissions. That's all.
The agony of this change? The agony of this change?
Yes, the agony of this change, changeover became all the more intense as a result of the position in which the Indian states were left under the Indian Independence Act of the British Parliament. The paramountcy of British Crown, against which the princes had been leaning, it should be, lapsed, and it was made clear that it would not be transferred to either of the succeeding dominions. There were three alternative courses open to them. They could accede to either of the two dominions or remain independent. This gave the prince himself the option to decide the fate of their states. Following the announcement of Mountbatten Plan on June 3, some of the Indian states acceded to Pakistan and some to India by means of instruments of accession executed through their princes. There were also some who entered into standstill agreements with either or both pending finalization of their decisions. The betrayal of the interests of the states' people had been expected following the rejections of the memorandum of the National Conference, and we in Kashmir decided to place the issue before the people themselves. This is how our well-known Quit Kashmir agitation began. The National Conference once led the people through a great struggle, and once again the ruler tried to curb it, this time with unprecedented severity. But when the whole people is one and the move it is not possible to repress them, and they do not stop until they wrest freedom and justice for themselves from the unwilling hands of those about them. The crucial date of India and Pakistan independence therefore came when I and my colleagues were still behind prison bars. The whole subcontinent was in a state of high tension and disturbance. If at that time the head of the state of Jammu Kashmir had even the slightest sense of realism or a proper awareness of the danger lurking in the situation, he would have immediately taken the people into confidence. By associating their representatives with administration, I am sure many of the complications that arose later could have been avoided. Instead of that, the Maharaja government entered into a standstill agreement with Pakistan, and this was accepted without question by that dominion. Now, the next is important. A similar arrangement was suggested to India also, but it is noteworthy that the government of India insisted that it could not consider any agreement entered into by the government of the state valid until it had approval of the people's representatives. While the leaders consistently refused to recognize the vital issue of accession without first securing the approval of his people, the Muslim League and Pakistan government supported the claims of the rulers to speak for their state. The late Mr. Jinnah took the position that after lapse of paramountcy, the princes were completely independent and that they could themselves determine what relations they should have with the two dominions. Throughout the struggles that the people of Kashmir waged against autocracy, we should never forget that the Muslim League leadership had completely dissociated itself from them, and that during the upsurge in 1946, their local party organs had assisted the administration to suppress the movement. At this crucial time, when Pakistan was under the cover of secrecy, perfecting its own plans, and the Dawn, the Muslim League official organ in Karachi, was appearing to the Maharaja to accede to Pakistan on the grounds that he would have great freedom there in India. It was at this stage, taking advantage of the isolation of the Kashmiris from the rest of the world, that Pakistan imposed an economic blockade upon us with a view to starving us to submission. Attempts were made even to excite communal hatred, to disrupt our peaceful civic life. Even in the face of such provocations, the National Conference, I'm proud to say, took an objective and democratic stand. Instead, immediately on my release from imprisonment, I clarified the issue of a mass meeting in Srinagar. The first and fundamental issue before us was the establishment of a popular government. Our objective might be summarized: freedom first, then alone could free people decide the future association through accession. I also made it clear that the National Conference would consider this issue without prejudice to political friends. So leave that around, Mullahs. Then Mullahs, kindly come to the paragraph. The overwhelming pressure of this invasion brought about a total collapse of the armed forces of the state, as well as its administrative machinery, leaving the completely defenseless people at the mercy of invaders. It was not an ordinary type of invasion, inasmuch as no canons of warfare were observed. The tribesmen who attacked the state in thousands killed, burnt, looted, and destroyed whatever came in their way. And in this savagery, no section of the people could escape. Even the nuns and nurses of the Catholic missions were killed or brutally maltreated. As these raiders advanced towards Srinagar, the last vestige of authority, which lay in the person of the Maharaja, suddenly disappeared from the capital. This created a strange vacuum and would have certainly led the occupation of the whole state by Pakistan troops and tribesmen if at this supreme hour of crisis the entire people of Kashmir had not risen like the solid barrier against the aggressor. They halted this onrush but could not stop it entirely, as the defenders had not enough experience training. This is the background on the basis of which the accession took place. Then Mullahs, kindly come to this paragraph. When the raiders, 1463, were last approaching Srinagar, we could think of only one way to save the state from total annihilation: by asking for help from a friendly neighbor. The representative of the National Conference therefore flew to Delhi to seek help from the government of India, but the absence of any constitutionalities between our state of India made it impossible for her to render us any effective assistance in meeting the aggressor. As I said earlier, India had refused to sign a standstill agreement with the state from the ground that he could not accept such an agreement until it had the approval of the people. But now, since the people's representatives themselves sought an alliance, the government of India showed readiness to accept it. Legally, the instrument of accession had to be signed by the ruler of the state. This the Maharaja did. While accepting that accession, the government of India said that she wished that as soon as law and order has been restored in Kashmir and our soil cleared of invader, the question of the state succession should be settled by reference of the people. Actuated by sincere desire to avoid bloodshed and further conflict, the government of India approached the Security Council in 1948 with a plan against Pakistan. The request was simple. The contention of India was that Pakistan was responsible for the invasion of Kashmir and was continuing to help the raiders who had been employed as mercenaries. And it was further said that legally bound, as India was to clear the Jammu and Kashmir state of raiders, might be constrained to pursue the invaders to their bases in Pakistan, which might lead to still bigger conflagration. India therefore wanted the Security Council to dispose of the case as quickly as possible in the interest of justice. That's how the question of plebiscite, Mullahs, came before the Security Council. Then Mullahs, paragraph, this is the essential background which we must fully take into account. Now I shall indicate some of the considerations which should be kept in view when you, the honorable members of the August Assembly, shoulder the grave responsibility of giving our considered opinion on this issue of accession, which affects not only the present generation of our people, but generations yet to come. Let us now skip the following paragraphs and then come to Mullahs, the real character. Mullahs, kindly come to paragraph. As a realist, Mullahs, that paragraph. As a realist, I am conscious that nothing is all black and is all black or all white. That there are many facts to each of the propositions before us. I shall first speak on the merits and demerits of the state succession to India. In the final analysis, as I understand it, it is the kinship of ideals which determines the strength of ties between two states. The National Congress has consistently supported the cause of the state's people's freedom. The autocratic rule of princes has been away and representative government have been entrusted with the administration. Steps towards democratization have been taken, and these have raised the people's standard of living, brought about much needed social reconstruction, and above all, built up their very independence of spirit. Naturally, if we accede to India, there is no danger of a revival of feudalism and autocracy. Moreover, during the last 4 years, the government of India has never tried to interfere in our internal economy. The experience has strengthened our confidence in them as a democratic state. The real character of a state is revealed in its constitution. The Indian constitution has set before us the country the goal of secular democracy. Well, as we may leave that out, then leave the other things out. and PDF 562. Speeches. No. Yeah, while the state.
Yes.
Is on 11th August 1952, soon after the Delhi Agreement in July 1952. And whereas in PDF 562 at 1921, he then explains why the provision is temporal. Here I would like to point out, my lords have that paragraph? Page 1921, PDF 562.
But after that, actually, we were reading at it goes on to about 1466, where he specifically speaks about the importance of the affiliation with India and accession to India. Because he speaks in terms of, first he speaks about the Indian Constitution.
That's correct.
Second, it's very important from a historical perspective. Sheikh Abdullah refers to the land reforms which were taking place post the First Amendment and the other amendments which took place to the Constitution. He says Pakistan, on the other hand, is a feudal state.
That's correct.
And therefore, our interests would not be protected in a feudal Pakistan as compared to an India where land reforms were taking place. Then he refers to the fact that, India has, of course, the access to the seas and therefore a better, as an economic powerhouse for us to carry on trade through the auspices of India. And this really continues until PDF page 107.
I didn't want to refer to it because it would take too long. Two, it's the background, but we're dealing with a temporary provision. That's why I didn't refer to it. But all that is very important. The reason is simple. Ultimately, what did J&K do? The people of J&K gave to themselves the constitution just as the people of India gave to ourselves this constitution. So central to all this is the will of the people. And therefore, you will have to compare it to the...
Very interestingly, see how Sheikh Abdullah puts it. He says the most powerful argument which can be advanced in her favor is that Pakistan is a Muslim state.
Yes.
And a big majority of our people being Muslim, the state must succeed to Pakistan. But then he says, this claim of being a Muslim state is of course only a camouflage. It is a screen to dupe the common man so that he may not see clearly that Pakistan is a feudal state in which a clique is trying by these methods to maintain itself in power.
Absolutely. She is right. The point I'm making, Mullahs, ultimately, what's the essence in this matter that your lordships are hearing? The will of the people of a state where the executive act of the Union of India, which decimates the will of the people. That's the issue before you. That's what your lordship, because all the three acts of the Union of India are executive acts. 356 deletes the proviso of Article 3. That's an executive act.
Mr. Sibal, look at the foresight of the speaker. He says, these days, economic interests and a community of political ideals more appropriately influence the policies of state.
Absolutely, absolutely.
He had this vision in 1951 when he was speaking about the importance of economic interest, which is what the world is talking about today.
Absolutely.
In a globalized world.
And in that situation, the ruler had no choice. Absolutely no choice. The point I was making is that we are now dealing with three executive acts. One, the 356. Two, change of interpretation in the definition of Constituent Assembly under 367(1) and the abrogation. These are all executive acts. The will of the people is not considered at all. That's the question. Can you delete provisions of the Constitution by an executive act? Can you decimate the Constitution by an executive act? Can you change the Constitution by an executive act? We're not talking about legislation here. We're not talking about parliamentary legislation. That comes after these executive acts, Mulats, are implemented. That's the question. That's the... You can't change the Constitution of India as applicable to Jammu and Kashmir by deleting Article 3, the proviso to Article 3. You can't do that through an executive act. You can't change the definition, Mulats, of the legislative, of the Constituent Assembly as legislative assembly through an executive act. Just then I'll come straight away to the issue, Mulats, 1921.
1921.
Yes, PDF, Mulats, 562.
Yes, volume? Which volume is this, Mr. Sibu?
Same volume, Mulats, same volume.
Volume 7.
Yes, same, Mulats, the same speech, Mulats, comes a little later.
19.
Sorry, same speaker comes a little later, Mulats. 11th August is the speech.
1921.
PDF page 562.
562, PDF 562. Sentence starting, Mulats, paragraph starting here, I would like to point out. My lords have that?
Yes, see some problem.
That's correct. That's correct. That's correct.
Yes.
All my lords have it, I'll read it. Here I would like to point out that the fact that Article 370 has been mentioned as a temporary provision, the Constitution does not mean that it is capable of being abrogated, modified, or replaced unilaterally. Kindly mark the words unilaterally, which is exactly what has happened. In actual effect, the temporary nature of this article arises merely from the fact that the power to finalize the constitutional relationship between the state and the Union of India has been specifically vested in the Jammu and Kashmir Constituent Assembly. That's how Mulats, Parliament understood it in 370. That's how the state understood it. It follows that whatever modifications, amendments, or exceptions that may become necessary, either to Article 370 or any other article in the Constitution of India in their application to Jammu and Kashmir, are subject to decisions of this sovereign body. Since a good deal of confused thinking and uninformed criticism is indulging us in the interest of, I would like to point out here that the Constitution has confined the scope and jurisdiction of the Union powers to the terms of the instrument of accession, with the proviso that they may be extended to such other matters also as the President may by order specify with the concurrence of the Jammu and Kashmir Constituent Assembly. The special problems facing the state were thus taken into account, and under the Constitution, the relationship approximated to that subsisting under the instrument of accession. The Constitution of the Indian Union therefore clearly envisaged the convening of a Constituent Assembly for the state of Jammu and Kashmir, which would be finally competent to determine the ultimate position of the state in respect of the sphere of its accession, which would be incorporated as in the shape of permanent provisions of the Constitution. This briefly is the position which the Constitution of India has accorded to our state. I would like to make it clear that any suggestions of altering arbitrarily the basis of our relationship with India would not only constitute a breach of the spirit and letter of the Constitution, but it may invite serious consequences for a harmonious association of our state with India. The formula evolved with the agreement of the two governments remains as valid today as it was when the Constitution was framed, and reasons advanced to have this basis changed seem completely devoid of substance. In arriving at this arrangement, the main consideration before our government was to secure a position for the state which would be consistent with the requirements of maximum autonomy to the local organs of state power, which are the ultimate source of authority in the state while discharging obligations as a unit of the federation. Then will us kindly come PDF 648. This is Mir Qasim's statement on 10th November 1952.
Okay.
And this is exactly what I've been submitting before your lordships from day one. A unilateral executive decision cannot change the terms of a relationship which are constitutionally embedded in Article 370. Was PDF 648, page 2007. This speech was given by Mir Qasim on 10th of November 1952. The statement of the Sheikh Mullah, that discussion on his statement continues. In the middle of that paragraph, starting, it is said that the accession of Kashmir with India should be, as far the statement is concerned, there can be no denying the fact that it should not be a dynamic in the sense that we give up our principles. On the contrary, accession should help us in achieving ideals and preserving our autonomy, except, of course, in the objects we handed over to India. Our assembly is competent to make laws and decide the issues, if any, since we are enjoying complete autonomy. We can even frame and amend our constitution. In this collection, we have application under connection. It should be with the application order of 1950 of the Indian Constitution. According to this order, all these powers do not vest in the state. Now, the next is important. We want to develop Kashmir according to the program of New Kashmir. Some people say that it is just possible that in future Kashmir may also become a part of India like any other state and get merged with it. In that case, our eternal economy will be reduced to naught and residuary powers will be snatched from us. In this connection, I will submit that the thinking of such people is morbid. These are the vested interests which create such misunderstandings. The representatives of the government of India have not kept any time limit for these residuary powers. This is important. That's why Mullah 370 talks about instrument of accession and the items in the concurrent list, but doesn't talk of list 2, which is the residuary powers of the state. Therefore, there should be no room for such doubts. We have acceded to India with a definite objective, and I am sure the objective will be achieved. Some interested persons are creating misgivings as regards the autonomy and say that Kashmir has been granted autonomy simply to benefit its Muslim population. But this is a baseless allegation. If the people from outside are not given the right of acquiring property in the state and getting recruited to state services, then it was not the Muslims of this place alone would get benefit, but all communities will also get benefit. Then will us kindly come to Mullah's, the social system which will be set up according to the program of New Kashmir will provide equal opportunities of development to all citizens of the state, be they Kashmiris, Ladakhis or Dogras. Now, Mullah, let's skip the rest.
690.
PDF page 694 now. Malas.
Formulate, now that we've seen the speeches, we'd like to formulate the principle which
The
your
principle is,
yes.
Malas, that an executive act of the Union of India cannot alter unilaterally provisions of the Constitution of India as applicable to the state of Jammu and Kashmir. That's the central
Cannot
submission.
alter unilaterally
Yes,
the provisions of the Constitution.
of India as applicable to the Jammu and Kashmir. Including getting rid of the special status given, acceded to by the Union, by the Government of India and by Parliament in enacting 370 of the Constitution. That's the submission.
Say it's an executive act.
I'll say 356 is executive, 367 definition is executive. These are all executive acts. Parliament came into the picture when the changes had already been done through executive acts. We're challenging that.
As you argued, the process was wrong.
Yes.
Whatever was done. But
Yes.
That is, the parliament did it.
No, Parliament accorded approval to the executive acts which unilaterally changed the constitution as it was applicable to the state of Jammu and Kashmir. That's the central question that your lordships will have to decide. Could Parliament have, could the Union of India have done it?
Is it your case that the parliament could have done it?
No, not at all. Well, that also I will answer. Well, let's kindly see. Ultimately, this was a political decision taken in the context of the situation then prevailing. Right? And the complete abrogation of Article 370 must also be a political decision. Well, your lordships will remember Brexit. What happened? In Brexit, what happened? There was no constitutional provision seeking a referendum. But when you want to sever a relationship which has been entered into, you must ultimately seek the opinion of the people. Because people are central to this decision, not the Union of India. It goes counter to the very grain of Article 370.
Mr. Vibal, in a constitutional democracy, seeking the opinion of the people has to be through established institutions,
Agree?
right? So long as a democracy exists, as it does, in terms of a constitutional democracy,
Yeah.
any recourse to the will of the people has to be expressed and sought in terms of established institutions.
I agree. So
That's the
either you
question.
do it,
So you
either
cannot-
you do it. Well,
You cannot envisage, therefore, a situation like a Brexit type referendum.
Yeah.
That's a political decision which was taken by the then government.
Yes.
But within a constitution like ours, there's no question of a referendum.
But this is a political decision that they have taken by unilaterally through an executive order, changing definitions. This is not some constitutional decision. That's what your lordships, supposing your lordships were to say that they can change the definition, or your lordships were to say.
But
That's
therefore, the ultimate question is whether the constitution does or does not interest that authority.
That's correct. That's all that I'm asking, Miller. I'm not asking for anything more.
And which in turn depends on whether 370 is construed as you say, a permanent feature, irrespective of the terminology used, because that is in the context of the changes till the Constituent Assembly was there, or is it something which is capable of being?
Well, let me see. That's a much higher level, Malas, to which I'm not, in fact, arguing that today. Malas, whether it is permanent or it is temporary, let's forget about it. The central question is, can the Union of India, in this manner, terminate that relationship that is constitutionally recognized in Article 370?
We understand.
It may not be permanent. It may be permanent. It may not be. You may change it. You may, you may
I
have.
said in the context that that was the argument earlier. So we have come to the next argument, which is the manner in which it is done
That's right.
is flawed according.
It's absolute. It's a fraud on the constitution itself, according to me. It is politically motivated. It is a political act. These executive orders are political acts. They're not constitutional acts. That's my submission. And whether it is a permanent feature or a temporary feature is really at the moment not an issue. The reason why it's not an issue is maybe there is a constitutional way of doing this. I'm not addressing that. Or have they resorted to that constitutional methodology? If they resort to it, it will be tested in a court.
And on the process, you said last time that, first, the section 92 power was vested in the governor,
Yes.
independent of the Council of Ministers. Step
36,
2,
38,
right. Now,
and
Step
92.
2, right. Step 2, the Legislative Assembly is dissolved by the governor under section 53 without aid and advice.
Yes.
3, the proclamation is issued under Article 356.
Yes.
You said that the object of the proclamation under 356 to eventually restore democracy.
That's right.
And not the decimation of democracy.
Right.
And then finally, we saw the amendment of Article 3 in the presidential notification.
That's right. That's
So
also an executive act.
all these 4 steps, according to you, were constitutionally flawed. There was no provision for these 4 steps because you've essentially taken away the powers of the State Assembly and exercised them under the garb of 356. That's the submission.
That's right. Absolutely. I'm deeply obliged to your lordship. But I just want to read one other.
Only one last thing which I wanted to ask you. You made your point on the process which was followed. They will have to answer it. On the proviso to clause 3 of 370, is there something ultimately that happened in the Constituent Assembly which sheds light on which way the Constituent Assembly was inclined to go?
Yes.
Because we are reading individual speeches. What happens thereafter at the end of this process
Well,
in
the
1957?
Constitution was adopted in 1957
Yes.
by the legislature of Jammu and Kashmir. Between 1951 and 1957, they could have determined or terminated the essence of Article 370, abrogated it themselves and said, there's no need for this constitution. We want to be a state, a part of India, like any other state. That is why 370 sub-article 3 referred to the decision of the Constituent Assembly. That decision could have been taken, but my lord asked me the question, well, now that there is no Constituent Assembly, how will this happen? If it were deemed to be a temporary provision. That's what my lord put to me. Right?
So your argument would be really, if I can put it that way, that the proceedings in the Constituent Assembly of the state of Jammu and Kashmir would indicate a reaffirmation of the arrangement under Article 370 as a long-term arrangement.
That's right.
So that the 3 options that Sheikh Abdullah spoke about, namely either of joining Pakistan,
Yes.
acceding to India, or remaining independent, they gave up the first and the third option.
That's correct.
They decide that the ultimate decision was to stay within the dominion of India, but subject to the safeguards of 370.
That's right.
And therefore, according to you, 370 assumes a permanent character, irrespective of the nature of the provision which is envisaged in the Indian Constitution.
And that's what Sheikh Abdullah said in his speech, that look, this relationship.
That still begs one question as to whether it was enough that the Jammu and Kashmir Constituent Assembly proceeded on that basis. Could 370, which was envisaged to be a temporary provision, be converted into a permanent provision merely by the proceedings of the J&K Assembly? Or was there some further act required from the Indian Constitution, either in the form of a constitutional amendment, by virtue of which 370 would cease to have a temporary character but have a permanent character, in implementation of the wishes of the Jammu and Kashmir Constituent Assembly?
Whereas Government of India never expressed a contrary opinion throughout.
But didn't it have to take place through a process of amending the Indian Constitution itself?
No.
To convert the character of 370.
All right. Whereas now your lordships are again going back on the issue of temporary nature. That temporary nature is not part of the Article 370. It's not part of it. It's not a part of 370, Madam. In fact, Muzaffar Beg says we didn't even know about it. That's why I want to read Muzaffar.
Mr. Sibal, there are 2 ways that we could really lead into this discussion. One, that though placed in Part 21, Article 370 was never intended to be a temporary provision. That's one. That's one layer of reasoning, which is what you're advancing. Two, that though it was temporary, the reason why it was placed in a temporary provision of the Constitution was pending the decision of the Constituent Assembly of Jammu and Kashmir, and therefore it was given the character of a temporary provision, because the views of the Constituent Assembly of J&K were still to be elicited.
Right.
Third, that's the second argument. We accept that for the purpose of hypothesis. The difficulty, of course, which we have to face is this. Assuming that that was why it was placed as a temporary provision, because the views of the J&K Constituent Assembly were still to be elicited. And we also take your point that the J&K Constituent Assembly decided to accede to India and reaffirm the accession to India subject to the safeguards of Article 370. Is that sufficient in itself to convert 370 into an unamendable or untouchable provision?
Let me assume, Manoj, that it is
Or was something more required by a parliamentary intervention in India post-independence to convert that which was essentially temporary into a permanent provision?
Let's assume, Manoj, that it is amendable for the sake of argument. Then, Manoj, how is to be amended? The Constitution must provide a solution, no, Manoj? I'll assume, Manoj, for the moment that it is amendable. Then how does the Constitution of India must provide a solution for that?
Once we concede, Mr. Sibal, that concede in the sense for the purpose of the hypothesis. We're not putting anything in your mouth, not at all. So I don't misunderstand that. Once we accept the fact that 370 is subject to the amending power under 368, then equally 370 provides for a modality through which 370 itself would come to an end.
Well, let's see 370 then, Manoj, and see what modality is. That modality can't be to convert a legislative assembly into a constituent assembly by definition through an executive act under 367(1). Then, Manoj, we have to find the modality within the Constitution, not outside it, not vested in an executive power of the Union. That cannot be. So if your Lordship puts to me, and rightly, that something more had to be done under the Constitution of India, we'd like to know what is that something more.
370 bracket 3 itself specifies the conditions in which the abrogation can take place.
Which is the Constituent Assembly it must be on the recommendation of the Constituent Assembly. So it gives the solution. That is in line with the federated nature of this provision. This is complete federation, whereas we are quasi-federal qua other states. But these are purely federal qua Jammu and Kashmir, because the residuary power vests, Manoj, in the state. So if you say, Manoj, that C70 sub-article 3 provides that solution, well, that is provided, certainly, but upon the recommendation of the Constituent Assembly.
And therefore, according to you, the power is completely lost once the J&K Constituent Assembly comes to an end.
Let me even not go that far. I'll assume that there is some power available. It may be 368. Let's say, it's hypothetical. We're not concerned with it.
No, Mr. Sibal, no. When you argue, then we'll have to take one. 360 is power to amend the Constitution. That's certainly there.
Yeah.
Now, when we look at 370 clause 3, now the issue would be whether 368 power is still available to amend the Constitution.
But your Lordship is not concerned with it in this matter.
No, it is. It's very, very crucial. Because once we accept the fact that Parliament as a sovereign lawmaking body has the power to amend everything including 368.
Yeah.
370.
Including 370.
Yeah.
Then any amendment of 370 may be subject to criticism on the ground of morality, but not power.
No, but it's not an action.
Maybe it's a political argument, but not a power. It's not an argument of constitutional power.
This is not action under 368. Your Lordship is not going to hypothetically say this is an action under 368 when 360 has not been invoked.
But then likewise, the exercise of power under 370 bracket 3, can it not be then criticized? It's a question of criticizing it as a political criticism. But is it an argument of the absence of power?
Where is that in 370?
And the
that
court
power?
is really, the court is concerned with either the existence or the absence of power, right?
Not that I should ask your lordships, where is that power in 370 that says that 368, you can do it under 360?
So 368 is the power to amend the
But
constitution.
we are not, are we concerned with that here? I'm sorry, Manoj, you require 2/3. You represent.
There are independent avenues. You have the power to amend.
Manoj,
You have the power within 370 to abrogate.
But Manoj, in that independent avenue must conform to the provisions of the Constitution. Well, an independent avenue derogates the provisions of the Constitution, is no avenue at all.
Mr. Sibbald, for the timing, if we ignore the proviso to clause 3, in fact, the clause 3 itself, independent of the proviso, gives the power to the president itself to abrogate 370. If we forget about the proviso.
Sorry, I'm sorry to say that, Manoj. Manoj, I'm really
Just
sorry.
read three-
There is a
just read it
proviso.
once again. Just read
You
it once
can't exercise that power without the proviso.
No, the proviso is something different. We are examining the proviso independently. But independent of the proviso,
The Clause 370 comes into play on the recommendation of the Constituent Assembly. Your Lordship is putting it the other way around. It comes on the recommendation of the Constituent Assembly that the President will exercise power, not the other way around. That's why I said you can't even initiate a bill. Your Lordship will remember that. You can't even initiate a bill. Forget about anything else.
Another problem is that then we would be redrafting the substantive part of clause 3 to postulate that the power under the substantive provision of clause 3 can be exercised so long as the Constituent Assembly of J&K is in existence. In which case, will the proviso not swallow up the main provision?
But that's what it says, that unless that recommendation is there, you can't exercise your power. President can't exercise power under 370, sub-article 3. It says so. You'll have to interpret it on its plain terms, Bharat, and the lordships have said it not once but several times over. And it's a provision which, in essence, is a provision of federalism. It's the heart of federalism, is this, Bharat. Yes, of course, it's a precondition. There's no doubt about it. I mean, whatever sophistry may happen, can't happen in this way, Bharat. And whereas 373 power has been exercised by the Constituent Assembly, saying no recommendation. I'll come to your Lordships a judgment of Sampath KASHMIR'S, which actually deals with this issue. So let's be clear, Manoj. Sorry.
Where does the Constituent Assembly specifically says that it doesn't the sub-article 3 will not apply to the. It only says that it only exercises the 3 choices. First, as to whether it should accede to the Pakistan or to India or to remain independent. Out of 3, it decides that it will accede to India. But where does it specifically say that it recommends that sub-article not be available?
Let me just, let's go back, Manoj, to 1950, 26th of January. Right? There was no Constituent Assembly. In fact, there was no decision. Originally, it was a National Assembly. There was no decision to convert it through adult suffrage into a Constituent Assembly. So Parliament, forget about the government, Parliament incorporated in 370 the provision for a Constituent Assembly. I asked myself this question, why? Why did Parliament do that? There was no Constituent Assembly in place. There was only a National Assembly. This must have happened in collaboration with Jammu and Kashmir. Must have happened, Manoj. That's why the term Constituent Assembly was included in 370 sub-article 3. Now, when they said in the proviso that it's on the recommendation, there was no Constituent Assembly. So it had to be a temporary provision. It couldn't be a permanent provision. And the preamble of the Constituent Assembly says to further define the relationship between Jammu and Kashmir and India. So it was temporary because there was nothing in place. it was not temporary because this provision had to go. No. Therefore, that relationship was to be decided by the Jammu and Kashmir Constituent Assembly, which had to affirm all laws that had been passed. Even the laws could not be passed till such time it were ever confirmed during this period by the Constituent Assembly. So the Constituent Assembly actually was exercising a dual role at that point in time. And the government of India in 1950, the Parliament, recognized that it is the Constituent Assembly on the recommendation of which 370 will be abrogated. There would have been no constitution of Jammu and Kashmir. Let's put it that way. There would be no constitution of Jammu and Kashmir, Malads, if 370 had been abrogated. It would be yet another state of India.
Mr. Sibal, you've made your point now. I think basically, as we see it, your argument is in three layers. We looked at the background, the history. We look at 370 in the background, the constitutional history, the other history which we saw pre-independence. We interpret 370 therefore in the context of that history, and then we've gone to the modalities which were followed for abrogation, which you have said is unconstitutional. Now, after having explored this terrain,
Let's
which
go
is the
on to
next,
the
where how do we now progress?
Come back to the list of dates, Malad.
Right.
Well, with your 2 minutes I'll take. There is a speech by M.A. Beg, Afzal Beg. Just it will take only...
Give us just the page and the gist of it, you can tell us.
At 694, PDF 694. It's only temporariness of the article. That's why that's the last person. You need not go through it. It refers to the temporary nature of the article.
It would be in the same vein as Mir Qasim's speech at 648.
And Mullahs, kindly note this, he was a representative of Jammu and Kashmir in India's Constituent Assembly. There were 3 members total, he was one of them. So he was part of the Constituent Assembly of India as well. I said that a good deal of criticism was leveled in both houses of Parliament of India and in the outside press in regard to the intention of 370, that it is a temporary article and the special position of Kashmir ipso facto is of temporary nature. This raised doubts and suspicions not only in the minds of the people of the state, but also in the minds of our colleagues sitting in this house about our relationship with India and Kashmir had peculiar position in 1947. It has now. That peculiar position is a permanent character of the state. It would be unfair to say that this position is a temporary nature. Statements have been made that in due course of time, 370 will cease to exist and Kashmir is bound to become a Part B state. Expressions like these have in fact given rise to amendments proposed by honorable members to the statements of the Leader of the House. Some of these amendments are critical and some are unfriendly. And then he goes on to say that we did not even know that there was a note, a marginal note in this regard. This has just come up suddenly. We didn't know that there was a margin. Nobody told us that there'd be a marginal note. So anyway, that's all that he says. I just wanted to invite my Lord's attention. So in my supplementary submissions, only I have set out these passages, nothing more than that. And so last try, so long as it is not completed, Article 370 will remain there. And when it reaches completion, we shall give to Paul what Paul's and what gives to Peter what Peter's. This is the center. That is, center will have the exceeded subject and the rest will remain here. 370 will have to be accordingly altered. It would not mean that Kashmir state will cease to have its special position. Amending 370 may be necessary at the time when we finalize our constitution. But even then, legally, constitution as it cannot in any way rob Kashmir of its special privileges and position given to it by common agreement. 370 is therefore temporary till we complete our constitution. That's the spirit with which it was incorporated in the Constitution of India. This is the point, Malad. Anyway, Malad, so that's what I've done with this. Now kindly come back to the list of dates. Well,
the list of dates are in...
We were at serial 71. in written submissions, compilation volume 2, PDF 53.
Volume
It begins with serial number 72.
Yes, serial number 72. Let's read 71, 3rd of August. The governor of the state of Jammu and Kashmir, my lord,
PDF, Mr. Civil, PDF?
PDF, my lord, 53, page 53 also.
Yes.
I'm sorry. Justice Call, my lord, has it?
Yes, that's why I said serial number 72, 5th August.
71, my lord, I just want to read 71 also.
71.
Governor of the state of Jammu and Kashmir gave a press statement on the night of 3rd of August that he was not aware of any proposal to amend 370 or Article 35A, and that all security arrangements and reinforcements of the state were being made pursuant to intelligence inputs forecasting a major terror incident. On the 5th of August at 11 a.m., on August 5, the President issued the impugned order titled the Constitution Application to Jammu and Kashmir Order 2019. This is CO 272. Well, let's therefore mark, it's an executive act. Said order issued under Article 371 with the purported concurrence of the government of the state of Jammu and Kashmir inserted Article 367(4) of the Constitution of India. So that's what CO 20272 did. In particular, the newly inserted Article 367(4)(c) stated that references in the Constitution to the government of the state of Jammu and Kashmir would be construed as including references to the governor of Jammu and Kashmir. Further, 367(4)(d) amended subclause 3 of Article 370 by replacing the expression Constituent Assembly of the State with the Legislative Assembly of the State. Executive Act. Now, let's come and look at that. It's in volume 3, PDF page 101. That's right.
Volume 3 of what?
documents.
Of documents.
Document.
Yes.
Page 101.
101. Turning page 494. Okay. Now, kindly note, Malat, at this point in time, 356 was in operation.
Volume, Mr. Civil, volume?
Volume 3, documents, volume 3, PDF page
Compilation. Documents compilation.
101. Note, Malat, at this time, 356 was in operation.
This is 5th August 2019 notification.
That's right. In exercise of the powers conferred by Clause 1 of 370 of the Constitution, the President, with the concurrence of the government of the state of Jammu and Kashmir, could never be done. Because other than 92, 36 and 38, Governor could only act on the aid and advice of the Council of Ministers. That's the Jammu Kashmir Constitution. The governor could not represent the state. So the very inception of this executive order is constitutionally flawed. In exercise of the powers conferred by Clause 1 of 370, the President, with the concurrence of the Government of the State of Jammu and Kashmir, is placed to make the following order. This order may be called the Constitution Application to Jammu and Kashmir Order of 2019. It shall come into force at once and shall thereupon supersede the Constitution Application to Jammu and Kashmir Order 1954, because all amendments thereafter were to the 54 order, as amended from time to time. All the provisions of the Constitution as amended from time to time shall apply in relation to the state of Jammu and Kashmir, and the exceptions and modifications subject to which they shall so apply shall be as follows. So, to Article 367 shall be added the following clause. 4. For the purposes of this Constitution as it applies in relation to the state of Jammu and Kashmir, reference to this Constitution or to the provisions thereof shall be construed as reference to the Constitution or the provisions thereof as applicable or as applied in relation to the state. Reference to the person for the time being recognized by the President on the recommendation of the Legislative Assembly of the state as Sadr-e Riyasat of Jammu and Kashmir, acting on the advice of Council of Ministers of the state for the time being in office, shall be construed as references to the Governor of Jammu and Kashmir. And references to the government of the state shall be construed as including references to the Governor of Jammu and Kashmir, acting on the advice of the Council of Ministers. How can that be? There is no Council of Ministers. So you create a constitutional myth. And assume in the absence of Council of Ministers that there is a Council of Ministers. And then you pass a presidential order that even in the absence of Council of Ministers, the governor is acting on the aid and advice of the Council of Ministers. What kind of exercise of executive power there is this? This is a mockery. Which is why I've been saying it's only a political act. It's not a constitutional act. You wanted to do something, you did it. He is even more serious. I don't think in any constitutional democracy in the world this has happened. In the famous Miller case in the UK, Boris Johnson tried to bypass Parliament and requested the Queen to prorogue the House. The House was prorogued. Immediately, matter came to the Supreme Court. All the justices of the court said, "No, your Lordship knows this is the executive power of the government. They can prorogue the House." But all came to a unanimous decision. You cannot even prorogue the House like this. You cannot exercise executive power to bypass Parliament. You bypass discussion in Parliament. That's not the way constitutional democracies work. And this is much worse. You assume something that doesn't exist. You give powers to the governor which he does not have. You assume to yourself under 350 all the powers of the state legislature. You are Parliament. So you therefore invoke the powers of the state legislature and Parliament, and you pass an executive order. What kind of exercise of law is that, or constitutional law? And then D, in the proviso to clause 3 of Article 370 of this Constitution, the expression Constituent Assembly of the state referred to in clause 2 shall be the Legislative Assembly of the state. What power does the President have to pass such an order? We're not dealing here with exercise of constitutional power. We're dealing with exercise of executive power. 367.
just as a test, from their perspective, why was the amendment to 367 necessary at all? Why was this crucial? I mean, we are seeing now the modalities which they have put into place for their constitutional design of ultimately abrogating 370. Why was this amendment to 367 necessary?
Because, brothers, they themselves gave the power of the Legislative Assembly, which they were exercising in 356 as the Constituent Assembly, and recommended. They were ad
Normally,
item with
when
my
a-
interpretation.
Yes.
They were ad item with my interpretation.
Right.
That you needed the recommendation of the Constituent Assembly. So
They
how do you
constitu-
reach there?
They constituted the Legislative Assembly as the Constituent Assembly.
That's, and Malaz, what they do is they don't interpret it. They say in Proviso 3 of 370, the expression Constituent Assembly of the state referred to in clause 3 shall read as Legislative Assembly. So they have amended Article 370 of the Constitution. Shall read as.
367 amendment was not required because you are exercising
Was.
power under clause 1 to say article.
No, it was required because you needed the recommendation of the Constituent Assembly.
No, that's something separate. But in 367, introducing clause 4, in terms of the notification dated 5th August 2019,
You required it because, Malaz, they changed the definition of Constituent Assembly in 370 as Legislative Assembly. This is why they could exercise power under 356. Please appreciate.
But suppose for a moment that they had not gone through this exercise of amending 367, all right, or introducing 367(4), and suppose we are operating purely within the fold of 356.
Yes,
All right, your challenge to the 356 notification is a different issue.
yes.
You're now just testing it as an exercise of power under 356. Once a proclamation takes place under 356, two consequences follow. One, the president assumes to herself all the powers of the state, the executive powers of the state vest in the president. Two, except the legislature, the powers of the state legislature. Two, the powers of the state legislature are then subsumed in parliament. The government of India does not in its executive capacity exercise the powers of the state legislature. Parliament has to exercise the powers. So once the proclamation under 356 was issued, two consequences would follow. All the powers which were vested in the executive of Jammu and Kashmir were transferred to the president.
Right,
All the powers of the state legislature were vested in parliament.
right.
Now, if that was so, then if 370(3) is capable of the interpretation, just as a hypothesis, that it's a power to be exercised by the president to abrogate. They abrogate. Point number two, any powers which were to be exercised by the state legislature would have to be exercised by parliament. So they had to go to parliament to get a resolution passed. Why was 367 necessary for the design, for the constitutional design to achieve this at all?
I tell you, 356 power cannot be exercised by parliament, by the governor, by the president and parliament in this fashion. Independent of 367, cannot be done.
Why?
Because you are only acting as the legislature. You don't have any powers independent of the legislature. Under 356, that's, Bomai has held that. You have no such powers. And the executive is only dealing with the administration. It can't amend the constitution under 356. Therefore, they had to do this. There was no choice. I'd show Manas Bomai.
Yes. But assuming for a moment that we suppose we disregard the 367 amendment.
Even if you do, then you can't exercise it under 356 at all. That's even Manas, it will be a dead letter. It will be inchoate. Because you can't amend constitutional provisions, Manas, through 356. You can only exercise the power of the state. Parliament can do it.
Fair enough. Therefore, if that part of the notification which amends 367 is kept aside for a moment, then what is the consequence?
The consequence is that 356 power cannot be exercised in the same fashion to
No.
achieve the same result.
See, the 356 power is the power of the state legislature
Yes,
and the state executive,
yes,
which has now been vested in the president and in parliament, respectively.
correct.
You may be right for a moment, subject to hearing them, that look, how can you exercise the power to amend the constitution by taking recourse to 356? Fair enough. We got that point and we'll hear them on that. But assume that we disregard this whole process of what took place under 367. Either disregard it or hold that it was constitutionally impermissible. Even so, does it affect?
That's a separate issue, Malad. I'll address your lordships on that.
Right.
At the moment, I'm on this executive order. I'll come to 356. I'll come to the other issues later, Malad. Because ultimately what you then do is Parliament is exercising power as a legislature and Parliament is exercising powers under 356 as well. Correct, Malad? And as a legislature of the state, let's assume, the state had to convert itself into a constituent assembly in terms of 373.
I think what they believed was they proceeded on a particular hypothesis that consultation with the Constituent Assembly is necessary.
That's right.
So therefore, they said that, all right, we are now going to replace the word Constituent Assembly by the word Legislative Assembly,
No,
which they sought to achieve by amending the
No,
Constitution.
it's a recommendation of the constituent, it's not
Yes.
just converting it. You can't.
The
therefore
first
you
step was to
recommend-
amend the Constitution.
Yeah, you recommend it to yourself because you have a political objective to recommend it and Mullahs, you take the decision yourself.
Yes.
This is a very problematic, Mullahs. And see the consequences of this. That means through an executive order, you can change any provision of the constitution. Because you have majority. This majoritarian culture cannot destroy the edifice of what our forefathers gave us.
So your argument, therefore, is that you cannot exercise the power under 356 to amend the Constitution.
Exactly.
That point you.
That's right. And they cannot possibly justify it unless there is some new jurisprudence that comes to light that they can do what they like as long as they have the majority. As it is, Mullahs, now one of your esteemed colleagues has said, Mullahs, that in fact basic structure, those theory is also doubtful. Maybe it is.
When we
After-
refer to a colleague, we have to refer to a sitting colleague. Once we cease to be judges, they are opinions, not binding diktats.
That's true. Of course it's not binding, Mullahs, but I'm surprised.
On 11th of November 19.
Parliament doesn't discuss what goes on in the court.
No, I'm not
Court
discussing
should not-
anything.
should not discuss what goes on in Parliament.
No, I'm not discussing.
Everyone, my lord, has a freedom
This
of
is a public
view,
sport.
freedom of expression.
No, I know. Mullahs, I'll assume he has the freedom of expression, what say to pay, what he likes. I don't dispute that, Mullahs. I'm just saying, Mullahs. Of course, absolutely. We're starting a debate on that because of this majoritarian culture again. I said that 356 was already in place.
Mr. Sibal is responding to the parliamentary debate here because possibly he was not there in the Parliament yesterday.
That is true. That is absolutely true.
It was that place where he could have
You are right.
expressed
You're right.
his views on basic
No,
structure.
not my view. I'm not, my view is clear because my view is the court's view. I can't go beyond that. But I am an officer of the court, Mullahs. In court, I have that constitutional view. Outside may have a different view. Mullahs, anyway, that's neither here nor there, Mullahs. It's just an aside, Mullahs. But there must be some element of humor and mirth in court as well, Mullahs. Not everything can't be this serious. We are
Yes,
dealing
Mr.
with- Mullahs, therefore, see the consequences of this. And Mullahs, then it is obviously clear that the government of India and Parliament recognized that the Legislative Assembly was the Legislative Assembly and could not be the Constituent Assembly, which is my interpretation. Therefore, it became necessary because they also knew that the Legislative Assembly can't be the Constituent Assembly. That's precisely what I've been arguing. It says shall read. This is an interpretation clause. Please appreciate 367 is an interpretation clause. It's not a clause to substitute definitions. If you look at 367, the heading is interpretation. It's not substitution. You can't substitute definitions. Only interpret. So it's outside of 367 itself, apart from many other things that I've pointed out.
What they've done is,
Very mature. Yes.